So I'll be reviewing several parts of this in a little bit more detail. I won't be going over the entire thing. The entire thing is actually in the packet that Mr. Hummel is providing. But as she was mentioning, in terms of inheritance, there is a specific section, Part 3, which deals with the issue of inheritance laws. And as Dr. Al-Hibri just summarized, inheritance laws are something which vary from country to country, and the complexity of the inheritance laws makes it difficult to generalize about the treatment of women, because depending on the circumstances, the same inheritance law could empower or inhibit. And so giving the example of Islamic inheritance laws, the ultimate objective of Islamic inheritance laws is to devolve wealth. It is well known that Islamic inheritance laws hold specific shares for each individual legal heir, and it is only in 2 cases in which female family members appear to be assigned a smaller share. What must be kept in mind, however, is that Islamic law, unlike many other legal systems, requires individuals to heir their property to relatives and spouses, both male and female, and prohibits disinheriting any relation. This, for example, prevents men from disinheriting female inheritors. And thus, women in all cases receive a share of inheritance. In many other systems, however, there is no stipulation requiring the inclusion of female family members as legal beneficiaries in a will. If an individual chooses, he can disinherit his daughters, for example, and they would thereby be prohibited from receiving any inheritance at all. And this comment is not included not to somehow promote or discuss the advantages or disadvantages of any legal system, but it's just to demonstrate that each legal system is different. It has its own nuanced laws, its own nuanced system. And so in order to, one, the first thing we need to do is we need to understand how these systems work so that we can actually promote actual change and empowerment for women. But the second component of this is we need to recognize that there are often components within legal systems which we consider to be uniformly discriminatory. There are often components within these systems which can often be very empowering for women. And if we encourage women to take advantage of these components, then these can often be vehicles of change in their respective societies in a way which a uniform civil code would not be able to offer. Okay. So an additional area which the concept note addresses under family law regimes is the issue of uniform civil codes as opposed to multiple legal systems. And we want to remind the CEDAW committee that advocating only for a uniform civil code in light of differing sociocultural contexts is not always the most effective or useful means of achieving greater rights and opportunities for women. Achieving women's empowerment involves understanding the laws and context of a given region based on input offered from the very women who are a part of these regions. In addition, it is the presence and acceptance of multiple legal systems of both religious and civil law which allows Christian minority communities in Middle Eastern countries such as Jordan and Egypt to retain the right to practice family law according to their own customs, as opposed to adhering to the religious laws of the dominant faith or to a uniform civil code which may inhibit their ability to adhere to their specific faith practices. By allowing such minority communities to practice according to their own faith traditions, albeit within international human rights norms, such states are allowing for multiple legal systems to exist. It is clear to any policy recommendor that to advocate for a required uniform civil code in such states like Egypt or Lebanon would actually be discriminatory towards such minority communities such as Coptic, Jewish, or Greek Orthodox communities in Egypt or Jordan, as it would be impossible for a strict uniform code to take into account the variation in lifestyle and practices of all faith traditions present.
We might add that it's going to be very hard. We might add it's going to be very hard on the one hand to argue for the rights of these minorities under international law when we're trying to pass another document which is really in opposition and conflict with these demands. So that's why I'm saying these kinds of issues, which are very broad and cut across many nations and many cultures and many religions, ought to be studied by an organization or a body which is concerned more than just about the issues that CEDAW is concerned about, because there are other important issues that figure into this formula.
Right, and so essentially In light of the need to protect free exercise of religion in religiously pluralistic regions, the need to advance family law reforms for the advancement of women, and the need to approach reform in a comprehensive and holistic manner that takes societal context into account, it is paramount for policy recommenders to push for reforms which advocate for state legal frameworks which allow individuals, in some cases, to elect under which system of family law they wish to be governed. Multiple religious family law codes should, right now, be permitted to coexist, and individuals should have the right to opt into using the one they prefer. By allowing individuals to elect the system under which they can be governed, individuals can choose laws which would be most appropriate for their specific context in an effort to promote egalitarian marital regimes which take into account differing cultural and faith traditions.
I want to say something also about that. You know, I think we live in an age these days where we want to give more freedoms to the individuals. We're moving away from totalitarian systems. We're moving away from straitjackets and ideologies that do not permit individuals to have enough personal freedom within their sphere. And in that regard, to have a one system imposed which takes away from the civil liberties, basic liberties of the individual to define their own family relationships, I think is very serious. It's quite an infringement on the individual human freedom. And why should we do that if we could reach the kind of results we want with much less interference and intervention in the privacy of the individual? Our views in various matters, whether it's family or governance, have all to be of the same cloth. We cannot speak about freedom on one side of our mouth and about imposing a uniform system with the other. We have to think consistently throughout our approach, not only in this document, but in developing a world order.
At the same time, it's very important to educate women about their options and about the legal tools they can use to protect themselves, which would be a necessary part of such reforms as well. And in advocating for that type of approach, it's not to say that women's rights are not important. Rather, it's to recognize that these situations are often very complicated, and we need to make sure that that religious pluralism is respected as much as the issue of women's rights, and that we work within these systems in order to advocate for women's rights. Another area which the document comments upon is dowry. And essentially the document states that dowry in all cases would be considered a form of buying and selling of human beings. And clearly, you know, in cases in which any individual is being exploited, be it a man, woman, or child, efforts should always be put forward in order to eliminate such exploitation. Likewise, transactions which involve the selling or buying of human beings at any level should be eliminated. However, a distinction must be made between the sale or purchase of human beings and the financial transactions, debt, settlement, or gifts which two individuals may rightfully choose to partake in as a part of a contract. The giving of engagement rings or jewelry in many cultures as a sign of intent to marry by a prospective spouse, for example, does not indicate the sale or purchase of an individual. Rather, such a gift is voluntarily given as an indication of commitment. What we should keep in mind, because this issue of dowry is actually is an emphasized issue in the document, is again it's very important to understand from a contextual perspective the role that mahar plays in many Muslim societies, and the fact that it is often a source of financial stability for women. And when we see this conflict of systems occur, many times we see, and when we see external legal systems often being superimposed on some of these societies in which mahar is seen as a negative thing, then what we see in many instances is that women are stripped of their rights to dowry on the one hand, and stripped of their rights to financial allowances as well, simply because these other financial allowances are often not recognized within these systems. Even in the United States, what we find is in the case Dajani v. Dajani in 1988, we found that a woman who was in a Muslim marriage was stripped both of her mahar provision as well as her American right to community property, primarily because of this misunderstanding of the financial rights within the Muslim marriage. And so again, this is not, it's very clear to express the importance of individuals not being exploited. Human beings should not clearly the buying or selling of human beings should